That said, I'm now kicking it over to our co-host for today from GRS Community Management, Courtney Buchan. Courtney, it's all yours.
Thank you so much, Jeff. Hi, my name is Courtney Buchan. I am the corporate trainer for GRS Community Management. I'm also a licensed property manager and a board member myself. So welcome to today's webinar on the homeowner board certification. So this is for homeowner associations only. If you're at a condo, you can stay, but you will not be getting certification for today's class. But welcome. So a little bit about GRS. We are a management company based out of Lake Worth, Florida. We service all of our great state of Florida. We manage over 200 communities. We provide full management services and accounting services to any community association, HOA, condo, co-ops. If you're interested, if you're happy with your current management company, we love that. But if you are not, you can always visit our website, grsmgt.com, to find out more about our services and request a free proposal for management services for your association. So today we have Kerstin Henze from K. Bender Rembaum. She is located out of the Tampa, their K. Bender's Tampa office. She is a firm member and managing partner of their Tampa location. Thank you so much, Kerstin, for providing today's certification course. We've done plenty of webinars together. She really knows her stuff. She's very thorough. K. Bender Rembaum, attorneys at law, one of the best in the business. They do the most for continuing education for board members and managers alike. Absolutely love working with them. Check out their website, kbrlegal.com. They're always updating their calendar with new events and courses for board members and managers. And they also record almost all of their webinars, and then you can go back and watch those and get a refresher on information or if you miss something. So love KBR for providing all of those resources. So with that being said, I'm going to turn it over to Kerstin. Thank you again. Anybody from GRS communities that are here today, appreciate you joining us. All other board members, great to have you. And I hope you get a lot out of today's webinar. So to you, Kerstin.
Thanks, Courtney. Hello, everyone. I'm Kerstin Henze, one of the attorneys with the firm, and I am located on the west coast of Florida, specifically in Tampa. For those of you who are not familiar with the firm, we are an exclusive community association law firm. So we represent primarily condominium, homeowners, and cooperative associations throughout the state of Florida. We do have other locations, including Orlando, Palm Beach, and obviously our main offices in Pompano. All right, so today we're going to go through the HOA board certification class. That includes all the requirements that are statutorily required and took effect July 1st of 2024. So I'm going to share my screen with the slides. And you will have access to the slides at the end of the class. All right, here we go. There's a lot of information on these slides, a lot of words. Obviously, I'm not going to read verbatim through everything, but they are in complete sentences to help you. So when you have a moment after the class, feel free to go back to the slides and reference them as you may need. And then, as Jeff mentioned, I'll answer questions. I'll try to get through as many questions as possible at the end of the webinar, and we have left some time specifically for that. Now, there is no statutory requirement for this class to be, 4 hours, or really, to take any specific amount of time. In the past, we have managed to get through this class in about 2 hours. Okay. So that's the time that you're expected to sit through this class, unfortunately. All right, so why are you here? Well, you are here because the statute was recently amended. Well, the original restriction has been in place for some time, which is that within 90 days of being elected or appointed to the board, you now have an obligation to complete a board certification class and attend one of these classes, with a provider that has been approved by the division to teach, which we are. Now, in the past, the requirement was for a board member to either attend one of these division-approved certification classes or sign a certificate that you have read your governing documents and you will abide by them. Well, that requirement was changed, and it took effect July 1st of 2024. Now, you absolutely have to take one of these board certification classes. Now, the certificate that you will receive at the end of this class is valid for up to 4 years. And a director has to complete this class, again, at least every 4 years, okay, as long as you serve uninterrupted. Now, the curriculum that has to be covered would have to include financial literacy, transparency, record keeping, levying of fines, and then notice and meeting requirements. So the slides include all of these statutory requirements and some. All right, so we've definitely added some additional information and literature for you to refer to. All right. Now, a director who does not timely take this board certification class and file a certificate of completion with the association is suspended from the board until he or she complies. Okay, and remember, again, you have 90 days from the date of being elected or appointed if you're elected or appointed after July 1st of 2024. For those directors who were appointed to the board prior to July 1st of 2024, the division has taken the position that such directors have up to 4 years to complete that requirement. Okay. Now, if there's a vacancy on the board that's caused by the failure of a director to attend one of these division-approved classes, then the board can temporarily fill that vacancy. Now, the association has to retain the director's education certificate for up to 5 years after the director's election. And the failure to have the written certification on file does not affect the validity of any board action. Now, once you've done this board certification class, in addition to that requirement, you have continuing education requirements, okay? And that is going to, the amount of hours of continuing education classes that you'll have to go through will depend on the number of parcels in your community. So if you are in a community with fewer than 2,500 parcels, you have to complete at least 4 hours of additional continuing education credits annually. And then if your community comprises of 2,500 parcels or more, then you have to complete at least 8 additional hours of continuing education annually. Okay. All right, Chapter 720. We'll talk about the purposes, application, and then conflicts with other statutes and laws. All right, so gave you here a little bit of a comparison of homeowners associations and then condominium associations, just so you can see the distinction. So homeowners associations, they exist with or without enabling legislation. Condominium associations, they only exist because of Chapter 718. Now, with HOAs, they're primarily a creature of common law, not statutory law. And HOAs own common areas, whereas the term common areas in the condominium setting is referred to as common elements, okay? And then HOA boards decide issues regarding typically material alterations, unless they're restricted in the governing documents. And we'll talk about material alterations later on. Whereas in condos, material alteration is an issue that is specifically addressed in the statute. All right. So the purposes of Chapter 720. So HOAs are governed under Chapter 720 of the Florida statute. You might have heard of Chapter 718 or Chapter 718. Those are chapters that specifically govern condominium associations, 718, and then 719 govern cooperative associations. Okay, but HOAs are exclusively governed by Chapter 720 of the Florida statute. So the purpose of Chapter 720, well, it's to give statutory recognition to corporations that operate residential communities. They provide procedures for operating HOAs, and it's intended to protect the rights of members without unduly impairing the ability of the association to perform its functions. Now, Chapter 720 does not apply specifically to any community that is composed of primarily intended for commercial, industrial, or non-residential use, right? Or to commercial industrial parcels in a community that contain both residential and then non-residential parcels or use. And it also does not apply to any association that is otherwise subject to the other chapters, 718, 719, or 721, unless those statutes specifically reference 720. All right. Well, which version of Chapter 720 will apply? Well, that is a complicated issue. We've tried to somewhat put some notes here to clarify this overly complicated process, but essentially it will come down to whether or not your governing documents have what is known as Kaufman language. Okay, Kaufman language includes these magical words as amended from time to time after reference to Chapter 720 in your governing document. So if your governing documents say that your association is subject to Chapter 720 as amended from time to time, what that means is any changes to the statute that come into play or are adopted after your declaration took effect will apply to your community automatically and will apply retroactively without the association having to amend the governing documents. Now, in the next slide, I mentioned what is the distinction of what is a substantive change. And a substantive change to the statute is basically a change to the law that affects vested rights of owners. Okay? And I'll give you an example in a minute. Now, if you do not have Kaufman language in your governing documents, then the constitutional argument that can be made is that the law that applies to your community is the law that was in effect when your declaration was recorded in the public records as to vested rights, okay? And the reason for this distinction or the reason for this argument is because there's a very basic premise in the law that the government, the legislature, cannot enact laws that impair existing contractual rights. So as you may be aware, your declaration of covenants, and we'll talk up in a minute about the what documents can constitute the governing documents of your community. Well, among them is this document called the Declaration of Covenants, right? It's the document that contains your use restrictions. For example, can you have pets? Can you, park a truck in your community? Those are your use restrictions, right? So The declaration of covenants is the contract between the association and those owners that buy property within the community. So the legislature can't enact laws that retroactively impair existing rights in this declaration, unless, of course, you have this Kaufman language, okay? In which case, new statutory changes will apply to your community. Now, that is with respect to vested, substantive vested rights, okay? And one example of this would be restrictions regarding leasing. So there is a provision in Chapter 720 of the Florida statute, and this went into effect in July of 2021. And it basically says that if you amend your declaration after July 1st of 2021 with regards to leasing, so if you amend your declaration to prohibit leasing or change the term of the lease, or how many times an owner can lease in the community, those specific amendments would only apply to owners who vote in favor of the amendment, and then those who take title to the community after the effective date of the amendment. Well, if you have Kaufman language in your declaration, that statutory provisions apply to your community, in which case, if you do amend your declaration to, let's say, prohibit leasing, well, you're subject to the statute, and then those amendments, if they're properly approved, would only apply to those owners who vote in favor and those who take title after the effective date. If you don't have Kaufman language, then you can make the argument that the law that was in effect, or the law that applies to your community, was the law that was in effect when the declaration was recorded. In which case, that 2021 law does not apply to your community, and then that amendment that prohibits leasing would apply to everybody, okay? That's how that would play out. So whether or not new changes in the law apply specifically to your community, that is something that you will need to get together with your legal counsel and have your legal counsel analyze and provide you with a legal opinion. Now, procedural changes as provided in this definition, they provide the means and methods for the application and enforcement of existing rights. So for example, the statute talks about election, right? So if there's changes in the statute regarding election procedures, well, that would be an example of a procedural change. Well, procedural changes will automatically apply to your community, regardless of whether or not you have Kaufman language, okay? All right, well, there is one other statute that governs your community. In addition to 720, there's this chapter that is Chapter 617 of the Florida statute, okay? And Chapter 617 of the Florida statute governs not-for-profit corporations, which is what your association is. Okay, so it really is a chapter that applies to all not-for-profit corporations in the state of Florida and really addresses corporate governance. So if there is a conflict between Chapter 617 and Chapter 720 of the Florida statute, the provisions of Chapter 720 will apply over those in Chapter 617. Now, if this page is not loading, let me try again. Here we go. Now, as I mentioned previously, your governing documents consist of primarily 3 documents, right? We've talked about the Declaration of Covenants or Declaration of Restrictions. Then there's the Articles of Incorporation, and then there's the bylaws. So we talked about the declaration being your contract between the association and the owners that buy into your community. It is the document that contains the use restrictions, right? So use restrictions really should not be in the Articles of Incorporation or bylaws. And more than condominiums, I've seen HOA bylaws, having use restrictions. They really need to be amended out of the bylaws, taken out, and then really put into the declaration for best and successful enforcement of those restrictions. Now, if there is ever a conflict, which there shouldn't, but if there is, the hierarchy of these documents is as follows. Your declaration is always going to be the supreme document. Then the articles, and then the bylaws. Now, the articles of incorporation and the bylaws, these two documents set out the corporate structure of the association, which is a corporation. Right, so it'll have things like, who qualifies as a member of the association, who qualifies as a director or an officer. It'll address how you have to conduct elections, whether or not the board can fill vacancies or how do you fill vacancies. So those are the types of things that the articles and the bylaws address. Articles, is a document that the developer needed to have filed with Tallahassee. And it's really, typically it's no more than 5 pages. So it's really very concise document. The bylaws are more of an extension of the articles and have more meat than the articles. So if there is ever a conflict between the articles and the bylaws on issues involving corporate governance, then the articles will control. All right, we'll talk about membership meetings. So there's 2 types of meetings that you're going to have, or 2 classes of meetings. First, there is the membership meetings, and membership meetings are meetings at which members vote. Okay, and then you're also going to have board meetings. Board meetings are meetings at which board of directors vote. Okay, so as for membership meetings, okay, there's 2 types of membership meetings that you will likely have. The one meeting that you're absolutely required to have every year is what is known as your annual membership meeting. Okay, if nothing else, that is the one and only meeting of the members that you will have. And the date, time, and location of that membership meeting will typically be set in your bylaws. Okay, so you'll have to look at the bylaws and see what time of the year, what date, what time, and what is the location of the annual meeting. And it might say something like, the annual meeting has to be held on the 3rd Thursday of every year, at the clubhouse. Whatever that says, that's where your annual meeting has to take place. Now, as a practical tip, you might want to consider amending such a provision if you have that, to maybe say that your annual meeting shall be held on such date, time, and location as determined by the board from time to time. This way, you'll have a little bit more flexibility in setting your annual membership meeting. That will require an amendment, which will require membership approval. So something that you might want to discuss with your legal counsel. Now, at the annual members meeting, the election of directors has to take place. So you might have other agenda items, and typically boards use the annual membership meeting as a meeting to present, the financial status of the community to the owners, or to discuss ongoing projects, the status of these projects, committee reports if you have committees. Typically, those are presented at the annual meeting. You might have other agenda items. For example, if you're looking to amend your governing documents, that might be a meeting at which you present the amendment to the owners for a vote. But if you don't have these other agenda items, that's fine too. At the very minimum, this is the meeting at which you're going to have your election of directors. Now, any other membership meeting other than this annual meeting will be called a special membership meeting, right? And when they're held, well, typically if the board, it has an issue or a matter that they want to present to the owners for a vote, and it is something that owners tend to get to vote on, like, amending the governing documents, or having to do with, a material alteration issue, which we'll discuss momentarily. If it's something the owners vote on, the board has the discretion and can present the issue to the owners for a vote at a membership meeting. Owners also have the ability to force the board to conduct a special membership meeting, and the percentage you'll need to force that meeting would be a petition by 10% of the total voting interest of the association, unless, of course, you have a different percentage in your governing documents. So, for example, if owners want to force an amendment to the document, well, as long as there's a petition by 10% of the voting interest, the board has to conduct a special membership meeting. Now, the statute does not require for annual membership meeting to have an agenda. As a practical tip, we always recommend for the meeting notice to contain an agenda. So you'll identify the date, time, location, and then agenda of that meeting. If you're looking to conduct a special membership meeting, then those do have to have an agenda. So you'll identify all agenda items, all items that you will be discussing at the meeting. As mentioned, notices have to have the date, time, location of the meeting. If your bylaws do not provide for procedure of giving notice of membership meetings, which means you have to go to the bylaws first, and if they're silent on how much notice of the meeting you have to provide, then Chapter 720 of the Florida statute says that you have to provide owners with at least 14-day notice of that meeting. A notice of that meeting can be mailed, can be hand delivered to the owners, or it can be electronically transmitted, meaning by email, but only to those owners who have consented to receiving official notices by email, which means you need to have a written consent from the owner saying, yes, I accept official notices from the association by email, and this is my email address. Evidence of compliance with this notice requirement has to be done by affidavit. So the individual that provides the notice, typically it's the property manager, but it could also be your secretary. Whoever provides this notice has to sign an affidavit attesting to having complied with this requirement. And as I mentioned, the last point here, again, can be mailed, delivered, or electronically transmitted. Now, a key point here is that if an owner has consented to receiving notices electronically by email, note that that email address does become accessible to owners. Okay, so if an owner decides, you know what, I don't want to receive any notices by email, or they don't want the email address to be accessible to other owners, and they revoke their consent to receiving notice electronically, then you have to remove their email address from the records, which are accessible to the owners. Electronic transmission cannot be used as a method for giving notice in issues involving recall of directors. That's the only time that you cannot email a notice of a membership meeting. Now, in addition to mailing, hand delivering, or transmitting notice by electronic transmission, the board has the option to adopt by rule a procedure for posting and repeatedly broadcasting the notice and agenda on a closed circuit cable television system serving the association. So if you have that capability, that is one other method by which you can broadcast notice of membership meetings. Now, in addition, and we'll talk about this in a few slides, but January 1st of 2025, right, you're supposed to have, if you're a community that operates 100 or more parcels, you are now required to have a website, right? And you are required now to post notice and agenda of member meetings on the website at least 14 days before the meeting. Now, the statute says that the notice must be posted in plain view on the homepage of the website or on a separate subpage of the website labeled notices, which is conspicuously visible and linked to the homepage. And then in addition to posting the notice of the meeting, you also have to post on the website any document that is associated with that owner vote. So for example, if you are having owners vote on an amendment, then that copy of the amendment has to also be posted on your website. Okay, and this website requirement took effect now January 1st of 2025. So hopefully you have all complied and have started a website if you operate a community with 100 or more parcels. So members have the right to participate. They have the right to attend and participate at membership meetings, which means they have a right to speak as to all items that are open for discussion and all items that are included on the agenda. Now, regardless of what you have in your current documents, the statute does say that an owner has the right to speak on any item for at least 3 minutes. Okay, so you can't deprive them of that, of those 3 minutes. You can, as a board, adopt reasonable rules governing the frequency, the duration, and other manner of owner statements, but again, can't limit the owner's ability to speak for at least 3 minutes. Membership meetings must also be held at a location that's accessible to physically handicapped persons if it is requested by the handicapped individual. And then, of course, any owner can tape record or videotape a membership meeting. The board can, however, adopt reasonable rules governing the taping of meetings. All right, quorum requirements for membership meetings. Unless you have a lower number provided in your bylaws, the statute says that quorum for an HOA consists of 30% of the total voting interest. Okay, so you might have a quorum requirement of 10%, of 20%. If it's anything less than 30, then you default to what's in your bylaws. If, however, you have a quorum requirement of a majority of the voting interest, majority of the members, then the 30% requirement in the statute is what will apply in that instance. Now, in terms of decisions or the approval required, the owner approval requirement, well, unless your governing documents or unless the law otherwise provide, decisions that require vote of the members must be approved by at least a majority of the voting interest present in person or by proxy at a meeting. So let me deconstruct this statement. So majority of the voting interest present in person or by proxy at a meeting. What this means is, let's take a community of 100 parcels just for easy numbers, okay? Let's assume that your minimum quorum requirement is 30%, right? The first thing that ever has to happen at a membership meeting is you have to establish quorum, right? That means the minimum number of homeowners that need to be present in order for the association to conduct and proceed with the meeting. So if 30% of the 100 parcels are represented at that meeting, whether physically in person or by proxy, okay, you've established quorum, the meeting can go on. So if 30% is the minimum number of owners that are there, majority of voting interest present in person or by proxy means majority of the 30%. As long as a majority of those 30% vote in favor of the action affirmatively, then the action passes. That's what that means. So it's not a majority of the 100, it's a majority of those 30% that are present at that meeting. But let's say at this particular meeting, let's say 60% of the homeowners showed up at that meeting in person or by proxy, okay? So now that voting percentage, right, is increased. So now it's a majority of those 60% who are there, right? Not a majority of the 100. So that's how that works. Of course, if let's say you're amending your documents and let's say you're amending your declaration, and your declaration requires the approval of 75% of all the owners, that would be 75% of the 100. Well, then that is the approval percentage that you need to obtain to get that amendment passed, not this majority of the voting interest present in person or by proxy. All right, and speaking about proxies, unless otherwise provided in the statute or specifically in your governing documents, members have the right to vote in person or by proxy. So a proxy typically is used if the owner cannot physically attend the meeting. To be valid, the proxy has to be dated, has to include the date, the time, the place of the meeting, and then it has to be signed by the authorized person, right, who's executing this document. Now, the proxy is good for up to 90 days from the date of the original meeting, right? So if you had your membership meeting on January 1st, that proxy is good for 90 days from January 1st. So the way that that this can be used is, let's say you don't get the necessary votes to amend your declaration at the January 1st meeting. Well, because the proxy is good for 90 days, that means that you can recess and reconvene that membership meeting up to 90 days to try to get the votes that you need. Now, there's a process to do that. I'm not going to go into the details of that, and you might want to consult with your legal counsel, but you can use that proxy, pretty much up to that last 98th day to get the votes you need. Now, proxies are revocable at any time, but by the person who executes it. And a proxy holder can also appoint in writing a substitute proxy. So let's say you've appointed your neighbor to be your proxy, right? And that neighbor can't attend the meeting. Well, if your proxy allows for substitution, then your proxy holder can then substitute and get someone else to attend that meeting for you. But again, if the proxy so provides. And then a copy of the original proxy can be used if it is a complete reproduction of the entire proxy. So you can, email or hand deliver a copy in advance of the meeting. Now, there are two types of proxies that you might come across. One is a general proxy and one is known as a limited proxy. Now, both proxies can be used to establish quorum, right? So if owners are not able to attend or don't want to attend a membership meeting in person, they can fill out a proxy and provide it to the association in advance, and that proxy will be good for purposes of establishing quorum. The general proxy allows the proxy holder to vote however he or she sees fit, whereas the limited proxy, okay, it lists the specific issues that the proxy holder may cast a vote for on behalf of the voting interest and then instructs the proxy holder how to vote. So with a general proxy, for example, if you're going to have an annual membership meeting, and you're not going to have any other agenda items other than your election, right? And you're going to use, maybe election ballots. I don't know what your election procedure is, but let's say you have specific election ballots just for the election, and there's really nothing else that you have on the agenda for that meeting. You can and you should send out a general proxy to the membership, because again, you need to still establish quorum in order to proceed with your annual meeting. So let's say, let's say for some reason you have to recess or reconvene that meeting, okay? Well, to recess and reconvene the meeting, owners who are physically present and those with those proxies, can vote then and there to recess and reconvene the meeting, okay? So that's one way that a general proxy can be used. Limited proxy. Let's say you are looking to amend your declaration, right? And you mail out the notice of the meeting at which the vote will take place, along with a copy of the proposed amendment to the owners. You will also need to mail out a limited proxy. So the limited proxy is actually going to have the question on it that you want owners to vote on. So it might have, for example, the question, do you approve amendment to section, 25 of the declaration? Yes or no? Okay, so we'll have the specific question right then on the limited proxy. And then the individual that is signing the proxy actually checks off how he or she wants to vote. Yes or no? Then the owner will sign the proxy. And then if you can't attend the meeting, you will identify on that limited proxy who's the proxy holder that will take that proxy with them to the meeting. And if you leave it blank, typically the proxy holder will default to an officer of the board. Okay, so that's how general and limited proxies work. Now, electronic voting, that's different from electronic notices. With electronic notices, remember those owners who consent to receiving notices electronically by email, right? They need to consent. Electronic voting is basically, it's a platform, it's an online platform by which owners can log in, vote online without having to attend a meeting. And Chapter 720 of the Florida statute authorizes boards to adopt or institute electronic voting for your community if you think this is something that would be beneficial, especially if a lot of owners are absent, a lot of owners are snowbirds. So with electronic voting, there is a misconception that owners have to approve e-voting. That's not the case. The only approval you need to get is the approval of the board. So the board is the one that votes at a board meeting by resolution whether or not they want to institute electronic voting. And the statute gives you basically the outline of what you need to do, and we've provided some of that instruction here. So the notice of the meeting at which the board is going to adopt electronic voting has to be provided at least 14 days in advance. And then we've identified here what the resolution has to provide. For example, the resolution has to provide that members will receive notice of the opportunity to vote through an online system. It has to establish reasonable procedures and deadlines for members to consent electronically or in writing to online voting, etc. And then once the board adopts electronic voting, well, the second part to this is that owners who want to vote electronically, well, they have to opt into the system. So they have to consent, not consent to the process, but only consent as to whether they want to vote electronically or not. And if an owner consents in writing that, yes, I want to be able to have the option to vote electronically, well, then from that point forward, on any issues that require membership approval, that owner can vote electronically unless that owner opts out of that process, right? And the opt-out also has to be in writing. And the beauty of electronic voting is that any owner who votes electronically is already counted as being in attendance at the meeting, so it's counted towards quorum. So they don't have to be physically present. They don't have to submit an extra, proxy to count towards quorum. The electronic vote already counts that owner as towards quorum. And obviously there are a number of vendors out there. For example, Get Quorum is one that comes to mind. That provide these online voting services. So you know, if you're interested, you should do your research as to, you know, which vendor best suits your needs. And then that voting platform has to meet certain statutory requirements, right? And we've outlined here basically what those requirements are. So I'm not going to read them to you. You can go back to it later. All right. Let's talk about elections. So a vacancy on the board that is caused by the expiration of a director's term must be filled by election, right? So typically, unless your governing documents provide otherwise, every director serves for 1-year term. When that 1-year term expires, well, that vacancy has to be now filled by election. As we've already discussed, elections must be held in conjunction with your annual meeting. And then very important, elections must be conducted in accordance with the procedure set forth in the governing documents. So it's not, you know, it's not an election procedure that the board may have adopted by policy. It is whatever election procedure is currently in your bylaws. That is how you need to conduct elections. You'd be surprised how many boards we've encountered who've, you know, decided all of a sudden, you know what, they want to adopt a condominium style elections. And more and more we've seen this trend of HOAs moving slowly towards, you know, condominium style elections, which condominiums have to provide 2 notices of their annual meeting, a first notice, a second notice. Owners have to, who want to run for the board, have to submit a notice of intent to run in advance. So in many ways, it's a less confusing process. And so more and more boards seem to tend to want to adopt that type of election procedure. However, if you're one of those communities that wants to change the existing election procedure, you have to amend the bylaws, okay? And you have to incorporate that procedure in the bylaws. Otherwise, your election is subject to legal challenge. Unless otherwise provided in the governing documents, a quorum of the members must be established in order to conduct an election. That is very different from condominiums where you don't need a quorum. You just need at least 20% of the voting interest to submit an election ballot. Well, with HOAs, you need to establish quorum. So if you do not have quorum at your annual meeting, you cannot conduct your election. Okay, in that case, the sitting directors will just roll over for another term, but you cannot conduct your election without quorum. And then unless otherwise provided in your governing documents, directors are elected by a plurality of the votes cast. So it's not, you know, who gets the majority, it's basically who gets the most votes. Candidate eligibility. Now, all members are eligible to serve on the board unless otherwise disqualified. And the statute gives you basically what the qualifications are. Anything other than this will not likely, any disqualification other than these criteria set forth here. So you might have in your governing documents qualification requirement. For example, most common one is that the director has to reside in the community for a certain period of time out of the year in order to serve on the board. Those eligibility requirements, unless they're in the statute, are likely subject to a successful legal challenge. Okay, so just be aware. Now, a person who is delinquent in the payment of any monetary obligation to the association on the day that he or she could last nominate himself, well, if they're delinquent by that last date, then they cannot be listed on the election ballot. Okay. Now, monetary obligation means not only assessments, delinquent assessments or special assessments. It could also be, you know, interest, late fees, certainly any fines. So any of those would qualify as a delinquent monetary obligation. If the member has been convicted of a felony in Florida, then that individual is not eligible to serve on the board unless his or her civil rights have been restored for at least 5 years as of the effective date on which he or she seeks election. And then any individual who has pending criminal charges for forgery of a ballot envelope or voting certificate, felony theft or embezzlement offense involving association funds or property, or tampering with physical evidence or destruction of or refusal to allow timely inspection of the official records in furtherance of a crime, or obstruction of justice cannot be elected to the board. Now, nominations. A member can nominate himself or herself as a candidate for the board at the meeting where the election is to be held. Okay, so the statute says that you have to allow nominations from the floor, unless, okay, if you have an election procedure in your bylaws that allows a process of nominations in advance of your annual meeting, then the statute says you can dispense with nominations from the floor. Okay, if you have nothing in your governing documents that allows owners to nominate themselves in advance, for example, requiring owners to submit a notice of intent to run prior to the meeting, if you don't have any of that process in place, then you have to allow nominations on the date of the annual meeting. Okay. On election day, typically, owners have the right to vote on election day in person or by proxy, unless, of course, your governing documents provide otherwise. So a typical HOA election, typical one, the way it would play out is, owners, you send out your notice of your annual meeting. Owners that come in will check in with the property manager or an officer. If they come in person, they get to vote on a ballot. If they come in with a proxy, typically it would be a general proxy, well, that individual can vote for themselves, and then they would vote an election ballot for as many proxies as they came in with. Then once quorum is established and nominations are opened on the floor, then owners who wish to nominate themselves will typically stand up, announce themselves as nominees, and then once nominations are closed, the names of the candidates are written on the election ballot, and then those owners who are present at the meeting will vote on the ballot. That is a typical HOA election. If you want to have something other than this process, then check your governing documents. You might need to amend. Now, if your governing documents permit voting by secret absentee ballot, again, you need to have something in your documents allowing owners who are not present at the meeting to vote by secret absentee ballot. If you have this authority in your bylaws, then the statute says that you have to follow basically what the condominium associations do. So your ballot has to be inserted in an envelope that's unmarked, and that envelope is referred to as the inner envelope. And then once that inner envelope is sealed, that envelope then has to go into a second envelope, typically referred to as the outer envelope. And on the outer envelope, there's going to be a designation for the owner to put their name, their lot or address, and then sign, and then a signature, okay, to sign for the election ballot. And so when those ballots are mailed in, the association, the board, through management, will have to verify the outer envelopes and then go through the process of verification before the votes are counted. Okay. Now, election by acclamation. So you're not required to have an election unless there are more candidates nominated than vacancies exist. right? So if you have a board consisting of 5 directors and all 5 seats are up for election, but only 3 individuals nominated themselves, well, obviously there are less candidates than there are seats, and so you don't have to have an election. In that case, those directors will sit on the board by acclamation on the date of the annual meeting. Now, if there is an election challenge, and one way that the election could be challenged is if you're not running your election in accordance with your governing documents. If any owner wishes to challenge the election process, well, that challenge has to be commenced within 60 days after the election results are announced. And typically election results are announced on the date of the annual meeting. So you have 60 days from the date of your annual election meeting to legally challenge your election. Now, the way to challenge the election, you have an option. You can dispute the election through binding arbitration with the Division of Condominium. And if you do that, then you are the election challenge would be subject to, you know, Chapter 718 of the Florida statute. So you kind of have to go through the condominium election dispute resolution. Alternatively, you can legally challenge the election process in court. All right, so once you're done with your annual meeting and you've elected the new board, you will adjourn the meeting. At that point, all directors are seated, and then you have to go through the process of organizing and electing your officers, right? Your officers are typically your president, your vice president, secretary, treasurer, and then any other assistant officers that the bylaws allow. So typically officers will be appointed by the board at a meeting, typically immediately following your annual meeting, and that meeting is called an organizational meeting. Now, your bylaws will typically have a provision that says when you have to conduct your organizational meeting, typically, you know, within 10 days of your annual meeting. And in my experience, most boards, you know, will just have their organizational meeting immediately following the annual election meeting. Now, at that meeting, really the only agenda item should be just to elect officers and reorganize your officer positions. It's really not a meeting where you're going to start talking about, you know, substantive association matters. That really should just be kept for a subsequent duly noticed board of directors meeting. Now, directors cannot vote by proxy or by secret ballot at board meetings, with the one and only exception that they can vote by secret ballot when electing officers. Okay. Now, there is no prohibition against changing officers midterm. So, for example, if the president is not doing their job, or if the president just, you know, no longer can serve in that capacity because, you know, whatever reason, the board can have a meeting to then reorganize and appoint someone else on the board to act as president, or, you know, you can switch positions. Just know that when you reorganize officers, or let's say you strip an officer of their title, let's say, you know, the treasurer is not doing a good job, you don't want that individual to no longer serve as a treasurer. That treasurer, if he's or she's a director, removing that individual from their treasurer position does not remove them from the board of directors, okay? So they will continue to serve as a director, just not serve in the capacity of treasurer. So important that you know that distinction. All right, fraudulent election voting activities. So these next few slides are a little wordy, but essentially any person who engages in the following acts of fraudulent election voting activity commits a first-degree misdemeanor. And we've identified here everything that the statute provides. So for example, willfully and falsely swearing to or affirming an oath or affirmation, or willfully procuring another person to falsely swear or affirm an oath in connection with or arising out of voting activities, perpetrating or attempting to perpetrate or aiding in the perpetration or fraud in connection with the vote cast, and the list goes on. So basically, don't do these things. Now, new law, effective July 1st of 2024, each of the following acts constitutes as a first-degree misdemeanor. So knowingly aiding, abetting, or advising a person in the commission of a fraudulent election or voting activity, agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent election voting activity, or having knowledge of a fraudulent election voting activity and giving any aid to the offender with the intent that the offender avoid or escape detection, arrest, trial, or punishment. Now, vacancies on the board. Unless your documents provide otherwise, any vacancy occurring on the board before the expiration of the term can be filled by the affirmative vote of the majority of the remaining directors, even if the remaining director constitutes less than a quorum. So let's say you have a board of 5 directors, and you know what? Everybody quit except one. Well, now you have one sitting director. Well, that one seated director can fill the remaining vacant seats. In fact, the one and only action that that single director can do is fill at least enough vacancies on the board to constitute a quorum. Because remember, without a quorum, you cannot conduct association business. So that one single director technically should not be conducting association business unless he has filled at least enough seats to create a quorum on the board. In the alternative to the remaining directors filling those vacant seats, the board can also hold an election to fill those vacant seats. And then any director that is appointed to fill a vacancy basically serves for the unexpired term of that seat being filled. All right, now let's talk about board of directors, board voting and decisions. So the officers and directors of an association have a fiduciary responsibility to the owners. They must act reasonably, right? And they must act in the best interest of the owners, not in their best interest or of any individual director, but in the best interest of the community. Now, unless otherwise provided in the governing documents or law, the association powers are exercised by the board of directors. So the board of directors, right? They're the ones that make the typically the day-to-day decisions of what goes on in the community, right? They approve contracts, they approve vendors. They approve, the hiring of employees. They approve, policies, maintenance or architectural approval procedures. Okay. Owners only vote on things that owners are allowed to vote. And that authority has to either be in your documents or it's something that the statute requires owners to vote. Other than that, it's a board decision. Unless delegated, no one board member should be making decisions for the board, right? Just like we discussed a slide ago about that single director, right? You need to have at least a quorum of the board to make business decisions. We talked about directors not being able to vote by proxy or by secret ballot at board meetings, with the exception of being able to vote by secret ballot only for election of officers. Now, members of the board can use email as means of communication. So you can email each other to discuss association matters. You just cannot vote on association matters via email, right? And please don't get into the habit of emailing, concurring in that email of, yeah, this is what we've decided, this is what we're going to do, and then basically rubber stamping that decision at your next duly noticed board meeting, right? Make sure that you have ample discussion at those meetings as to the decision that the board arrived at or will be making, so you're not just rubber stamping decisions. Board meeting notices. So again, a board meeting is a meeting at which the board of directors votes. And in terms of the notice requirements, okay, board meetings, just like membership meetings, you have to identify the date, the time, the location of your meeting, and you have to identify all agenda items that you will be discussing at that meeting. Whether it's, consideration of, a contract, or consideration about, a maintenance issue, whatever it is, they have to be listed on the agenda. If you're going to be adopting assessments, okay, assessments cannot be levied at a board meeting unless the notice includes a statement that assessments will be considered and the nature of the assessments. Now, unless your governing documents provide otherwise, there's really two time frames for notices, for providing notices of board meetings. So typically, unless your documents say otherwise, notice of board meetings typically just get posted on community or association property at least 48 hours in advance, unless, of course, there's an emergency. That is for most meetings, unless your documents say otherwise. So if you have bylaws that specifically say that board meetings have to be noticed 10 days in advance, well, then you go with what your bylaws provide. The statute also says that unless otherwise provided in your bylaws, okay, if you're going to adopt a special assessment, or if you're going to adopt an amendment to a rule concerning parcel use, those notices have to be specifically noticed at least 14 days in advance. And you can provide notice of that meeting by mail, hand delivery, or electronically to those owners who have consented to receiving notices electronically, okay? So in addition, the association can adopt by rule a procedure for posting board meeting notices and agendas on a website, and you're also required to physically post them on the community. The notice, though, has to include a hyperlink to the website or the application on which the meeting notice is posted. Again, you should have already complied for this, but for those communities who operate 100 parcels or more, you have to have a website for posting notices of board meetings and agendas, as well as any other document that is associated with a board vote. So if, for example, you are having a board meeting to approve a contract, well, a copy of the contract has to also be posted on that website. Member participation at board meetings. So just like members have the right to attend and participate, speak at membership meetings, they have an equal right to attend and speak at board of director meetings. The only meetings that are not open to owners are meetings between the board and its attorney. If you're going to be discussing proposed or pending litigation, and then any meeting held for purposes of discussing personnel matters. Those are the only two meetings that are not open to owners. Otherwise, any other meeting is open to the membership, and owners have the right to speak with reference to all designated agenda items. Now, the board can also adopt rules governing the frequency, the duration, and then other manner of member statements. Now, unlike with the membership meeting, there is no statutory provision providing a minimum allotted amount of time for owners to speak at board meetings. But given that for membership meetings, owners have to be able to speak at least 3 minutes, a requirement or a restriction that owners be able to at least to speak at least 3 minutes at board meetings it would be a reasonable rule. Owners also have the ability to tape record and videotape board meetings, just like they do with membership meetings, and the board can certainly adopt rules governing the taping of meetings. And again, just like with membership meetings, board meetings must also be held at locations that are accessible to physically handicapped persons if that is requested. Now, compensation for directors, officers, or committee members. They cannot be directly compensated or receive any salary in connection with their duties as a director, officer, or committee member. The only exception to that is they can participate in any financial benefit accruing to all or a significant number of members as a result of actions lawfully taken. They can be reimbursed for out-of-pocket expenses incurred on behalf of the association. They are entitled to recover insurance proceeds derived by a policy of insurance maintained by the association. And then they are entitled to any fee or compensation that's authorized in the document or one that is approved by a majority of the voting interest, voting in person or by proxy. All right, so other than that, there is no officers, directors, or committee members cannot be compensated for their services as a director, officer, or committee member. Now, an officer, director, or manager also cannot solicit, offer to accept, or accept a kickback. And a kickback is defined in the statute as anything or service of value for which consideration has not been provided for an officer, director, manager's benefit, or for the benefit of their immediate family members from any person that's providing goods or services to the association. If an officer, director, or manager knowingly violates this prohibition, they commit a third-degree felony and they are subject to monetary damages. An officer or director violating this prohibition must also be immediately removed from the board, which creates a vacancy that can then be filled by the board. However, an officer, director, or manager can still accept food to be consumed at a business meeting with a value of less than $25 per individual, and they can also accept services and goods received in connection with trade fairs or education programs. So those of you who, if you haven't done so yet, well, there's expos, trade shows for HOAs and condominiums, and board members typically get to walk and see vendors. And vendors typically give out, goodies, knickknacks. You are allowed to receive goods at those trade shows without being in violation of the statute. All right, grounds for immediate removal. A director or an officer that is charged by information or indictment with any of the following crimes must be removed from office. So forgery of a ballot envelope or a voting certificate, theft or embezzlement involving association funds, tampering with physical evidence, obstruction of justice, or any other criminal violation under the HOA statute. The board must fill the vacancy at the end until the end of the period of the suspension or end of the director's term, whichever occurs. But if the charges are resolved without finding of guilt or without acceptance of a plea of guilty, then the director or officer must be reinstated for the remainder of his or her term. Also, if a director who's currently serving on the board, if they become more than 90 days delinquent in the payment of any fee, fine, or other monetary obligation to the association, well, they're deemed to have abandoned their seat on the board, creating a vacancy. Okay, it's an automatic abandonment. All right, conflict of interest disclosure. So directors and officers have to disclose to the association any activity that can be reasonably construed as a conflict of interest at least 14 days before voting on the issue or entering into a contract that is the subject of this conflict. Now, there is a rebuttable presumption of a conflict of interest if any of these acts occur before they are disclosed. Either the director, officer, or a relative of a director or officer enters into a contract with the association, or the director, officer, or relative of the director or officer holds an interest in a corporation or an entity that is looking to get into a contract with the association. Okay, so if any of these two things happen, there is a conflict of interest and it has to be disclosed. Now, the statute doesn't prohibit a director or officer to enter into a contract with the association, or it doesn't prohibit the entity in which a director or officer has an interest from entering into a contract with the association, but there are certain steps that need to be taken in order for that contract or transaction with a director or officer to be properly approved. And what they are, well, I put them here on this slide. So the first thing is that the proposed contract with the director must be fully disclosed to the board, right? The disclosure has to be reflected in the minutes of the board meeting. And then the board has to approve the contract or the transaction has to be approved by at least 2/3 of the directors present. The contract or the transaction with the director obviously has to be reasonable and fair to the association. And then the last step, and this is the one that most boards fail to do, is at the next regular or special meeting of the members, the existence of that contract or that transaction that was just approved by the board, well, that has to be disclosed to the membership. And then the membership can cancel that contract or the transaction if it's approved by a vote of the majority of the members present at the meeting. Okay, so the board can approve that transaction that is subject to conflict of interest, but the owners can then vote to cancel it. Okay, now if the members vote to cancel that contract or transaction, then the association really is only responsible for paying for goods or services incurred up to that cancellation date, and the association wouldn't be subject to any monetary penalties or liquidated damages for early termination. All right, we're about an hour and 20 minutes into this. Official records. So I've identified here in this slide, basically the official records that the association has to maintain, okay? Not going to go through all of them, but essentially here they are. And they include, your governing documents, your rules, contracts, etc. Now, most of the official records have to be maintained at least for 7 years, unless, of course, your governing documents provide for a longer period, with the exception of excuse me, bids. They only have to be kept for a year, and then any other, I think it's in this slide, right here, ballots or signing sheets, voting practice, really, or any other document in connection with an owner vote. Those only need to be kept for 1 year. And then effective July 1st, the association has to adopt written rules governing the method or policy by which the official records are to be retained. Now, most official records are accessible to all owners. There are a few exceptions, which we've identified here, including obviously any record document that is protected by attorney-client privilege, any information obtained in connection with the approval of a sale, lease, or other transfer. So if you are one of those associations that are authorized to approve or disapprove sales or leases, any information you obtained in that process, whether it's the application or the credit report, the criminal report, any of that has to be kept confidential, can't be disclosed. For the sake of time, I'm not going to go through the other items, but here, for example, telephone numbers, email addresses, unless the owner has consented to receiving notices electronically, those email addresses are not accessible. Medical records, should we receive any medical records or any information, medical information from an owner, and that typically might be if an owner is requesting some kind of accommodation under Fair Housing Act. Again, all of that is not accessible. Attorney-client privilege, well, really any record that is created by the attorney, will be protected by attorney-client privilege. So if you, for example, seek legal guidance from your legal counsel and your legal counsel provides a legal opinion, well, that is subject to attorney-client privilege, unless, of course, the board decides to waive that privilege. That is only at the discretion of the board. The association can print and distribute to owners a directory containing the name, the lot address, and telephone numbers. However, an owner has an option to opt out and exclude their telephone numbers from that directory. An owner can also provide written consent to the disclosure of other contact information which is otherwise not accessible. Now, a new law that took effect July 1st, and hopefully you've already complied with it, but before October 1st of 2024, every HOA was required to provide either a physical or a digital copy of the association rules and covenants to every member. So this needed to have been complied with prior to October 1st. If you haven't done this already, then you should be doing this right away. So you have to provide either a physical or a digital copy of rules and covenants to the owners. And one way of doing that is if, as an option, you can post, you can comply with this requirement by posting a copy of your rules and covenants or a link containing this document on the association website. If you are going to do that option, then you still have to provide notice to the owners, letting them know that these documents are available on the website. And that notice can either be emailed to those owners who have consented to receiving notices electronically or mailed. Now, access to official records. Unless otherwise provided in your governing documents, the records have to be made available within 45 miles of the community or within the county, and they have to be made available within 10 business days after receiving the written request. Now, the statute does say that if the request was submitted by certified mail, return receipt requested, okay, and access is not timely provided, then there is a rebuttable presumption that the association will willfully fail to comply. So really you have 10 business days from receipt of a written request. Now you can make the records available by either having a copy of the records available for inspection, so you can have the owners come in and do the inspection. You can make the records available electronically via the internet, or you can allow the records to be viewed in an electronic format on a computer screen, okay, and then print the records out if copies are requested. Now, if the association does not timely comply with the records inspection request, then the requesting owner is entitled to damages of $50 per calendar day, up to 10 days. And that calculation begins on the 11th business day after receipt of the written request. Another law that took effect July 1st of 2024 is that if the association receives a subpoena for records from law enforcement, the association must provide copies of the records or make them available for inspection within 5 business days after receipt of that request. The association also has to assist law enforcement agency in the investigation. New changes to the law that took effect of July 1st. Well, they now criminalize certain type of conduct having to do with denying access to official records. So effective July 1st, any director or manager who knowingly, willfully, or repeatedly fails to provide access to official records, and the term repeatedly means at least 2 or more violations in a 12-month period. And if you do this willfully and repeatedly with the intent of causing harm to the association, well, you commit a second-degree misdemeanor, okay? Again, this is not, inadvertent, negligently, failing to allow access to records. You miss the deadline, right? This is willful, knowing, and repeated violation. Also, a person who knowingly and intentionally defaces or destroys accounting records, or knowingly, intentionally fails to create or maintain accounting records with the intent of causing harm to the association, well, that is a first-degree misdemeanor. And then any person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or to assist another person with such avoidance commits a third-degree felony. So the association can, and you should, as a board, adopt reasonable rules regarding the frequency, the time, location, notice of records being inspected. And we've assisted many associations when adopting these types of rules. What you cannot do, however, in those rules is require an owner to show any proper purpose of that inspection. Okay, so you can't force them to tell you why they're wanting to look at these records. You can't require the owner to state any reason for the inspection, and you cannot limit the owner's right to inspect records less than 8-hour business days per month. Now, if an owner comes to the inspection with a portable device, so a smartphone or a tablet, they can scan and make copies of any official record free of charge. You can't charge them. Otherwise, if an owner requests copies of records, the association must provide them with copies, obviously at an expense, and the statute tells you here what you can charge. So I'm not going to go into details, but you can take a look at that. All right, association websites. We've already mentioned this a number of times, but again, at this point, any association with 100 or more parcels, you should already have a website to maintain association records. And then upon a written request by an owner, the association obviously has to provide username and password access to the owners. I've identified here the types of documents that the association has to post on the website. You can read that at your leisure. Some of it, which we've already discussed, including notices of membership and board of directors meetings, and you would have to post them on the website within the same notice requirements as you would have had to, post or mail them otherwise. All right, let's quickly talk about amending the governing documents. So in terms of, the vote that you need to amend your governing documents, well, that's going to depend on what document you're amending, right? So if you're amending the declaration, you got to look at the declaration to see what is the voting percentage set forth in the declaration that you need to obtain. If you want to amend the bylaws, you got to go to the bylaws, and there should be a provision there that tells you how many owners need to approve an amendment to the bylaws. If, however, your documents happen to be silent, and some of the older HOA documents sometimes are silent on the approval requirement, well, then the statute says that an amendment to the governing documents has to then be approved by 2/3 of the voting interest. So 2/3 of all the owners. Now, in terms of the format, well, you will have to type up your amendment, and then you have to designate the changes with either underlines if you're adding new language, or you got to put a strike through, cross out any words that you are removing from your document, right? The alternative to that is if you want to do an amendment that does not designate underlines and strike throughs, that you have to put verbiage right at the top of the amendment, which says, substantial rewarding, see governing documents for current text. The drawback of doing it that way is that obviously owners don't get to see exactly what you're adding and what you're removing, and not many owners want to pull out the old deck to compare. So you just gotta, figure out if that's an effective method of presenting an amendment to the owners in your community. And then the other thing you want to be on the lookout is that your documents might require mortgagee consent on the amendment. And if that's the case, then the statute provides a process for obtaining mortgagee consent. It's not, it's not a difficult process, but it is a process that you would have to go through if you don't want to subject the amendment to legal challenge. If you don't obtain mortgagee consent, well, mortgagees have 5 years from the date the amendment is recorded to legally challenge the amendment. So any amendment only becomes effective once approved by, the membership. It becomes effective when it is recorded in the public records. Okay. And once you have an amendment approved and you've properly recorded the amendment in the public records, then the statute says you have to provide a copy of the amendment to the owners within 30 days of the recording. Now, if you have previously provided the owners with a copy of the amendment, and you would have given the owners a copy of the amendment when you sent the notice of the membership meeting in which they were going to vote on it. So if they've already seen the amendment and no changes were made to that amendment, well, instead of sending another copy of the amendment to the owners once it's been recorded, you can just send them a notice letting them know, hey, the amendment has been recorded, and you need to provide the book and page number of the public records where they can access that amendment. We've talked about the leasing restriction when we talked about Kaufman language, so I'm not going to discuss it. We'll just move forward here. All right, a few gems. Here's a couple of just practical things for you to be aware of. So in terms of governmental filings, okay, we discussed that the association is a corporation. not-for-profit, right? And articles of incorporation for the association at one point or another should have been filed with the Division of Corporation in Tallahassee, okay? So for the association to maintain an active corporate status, every year the association has to file what is known as the annual report, right? That annual report gets filed with the Division of Corporation, and you can do that electronically on their website, which is sunbiz.org. And if you have a management company, typically that is done by the management company. But the report gets filed between January and May of every year, and there is a small fee to do that. If you file the report past the May deadline, well, obviously there is additional fees that you need to file, and you risk the association being involuntarily dissolved. So you would have to basically, file the report for the association to be an active corporation. You also have an annual income tax filing that you have to do every year. So while the association is a not-for-profit corporation, it doesn't mean it doesn't have to file a tax return. So for that, be sure to consult with your CPA. Meeting minutes. Every meeting you have, whether it's a board membership meeting, you need to take minutes, right? Typically, that is the function of the secretary, but you might have your property manager take minutes if that is part of your management agreement with a management company. As a practical tip, minutes do not need to be verbatim, right? You're not, typing up a transcript of what everyone said at the meeting, right? The minutes really should just reflect, date, time, location, who attended the meeting among the board members, if it's a membership meeting, whether quorum was achieved, and then the motions that were made, who made it, who seconded, and then who voted, how was whether the motion passed or not. Okay, that's about it. Otherwise, you subject the association to potential legal exposure. Material alteration, that's a term that we've sort of mentioned at the beginning of the webinar. So the term material alteration is, it's a concept that was developed within condominiums, and case law has defined material alteration really as it means to palpably or perceptibly vary or change the form, shape, elements, or specifications of a building from its original design, plan, or existing condition in such a manner as to appreciably affect or influence its function, use, or appearance. So what that means is if you have a tennis court and you want to turn it into a pickleball, or you want to turn it into basketball court, that is a material alteration or change to a common area. Now, Chapter 720 of the Florida statute does not expressly address these types of material changes to common areas like it does with the condominiums. That said, you could have a provision in your governing documents that might require membership approval before the association makes any changes to the common areas or association property. Okay, so if you are contemplating in changing the appearance of any common areas or association property, be sure to look at your governing documents first to see if there's any membership approval requirement. And that approval requirement might even come in the form of a dollar threshold amount that the association could spend. So your documents might say, the board, can spend up to 5% of the annual budget on any changes to the common areas. But anything, if the change will cost more than that threshold, then you need the vote of the majority of the owners, something like that. So just be aware and be sure to look before you undertake any material changes. Rule adoption. So your ability as a board to adopt rules, well, that that authority is derived from your governing document. So you have to look at your documents to see if you have the authority to adopt rules. Typically, boards do have authority to adopt rules concerning common areas and recreation facilities, but I'm seeing more and more of the older documents not giving boards authority to adopt rules concerning parcel use, okay? So check to see what authority you have, and it might be that you need to amend your documents to give you that, that authority. Now, if you're going to adopt rules regarding use of common areas or facilities, that type of meeting typically just requires a 48-hour posted notice. If you are going to amend rules regarding parcel use, well, the statute specifically says that notice of that meeting has to be provided to owners at least 14 days prior. So, for example, if you're going to be adopting specifications regarding, hurricane protection affecting the lot, that is a type of, rule or architectural guidelines that I would specifically provide 14-day notice to the owners. Marketable Record Title Act. Basically, this is Chapter 712 of the Florida statute, and it is a very complicated area of the law, but what it essentially means is that your HOA covenants are typically good for 30 years, after which they will expire unless you take action to preserve your documents. And there is case law that specifically says that it is your fiduciary obligation to make sure that you preserve your covenants before they expire. Okay. Now, there are ways to preserve them before they expire. And if you take timely action to preserve the documents, well, that only will require a board vote. If, however, you fail to timely preserve your documents and they have expired, in addition to a host of legal consequences that come from that, well, you have the option, or not the option, but you have the ability to revitalize those documents after expiration. But at that point, revitalization will require membership approval. Okay, and we've assisted many clients with either process. So if you have legal counsel, be sure to consult with them when your documents expire, what you can do to preserve them, or if they've already expired, what you need to do to revitalize them. Otherwise, we're happy to help. Emergency powers. I'm not really gonna talk about it in detail, other than just wanted to point out here that the statute, which is 720.316 of the Florida statute, does give associations certain emergency powers. A lot of these powers were invoked during COVID, and as a result of COVID, the legislature did update and make some revisions to the statute. So I put them in the slides here for you to review at your leisure. Debit cards. This was a new, a provision of on debit cards has been in the statute for some time, but the first bullet point was a new change in the statute, which says that an association, its officers, directors, employees, and agents cannot use a debit card issued in the name of the association or billed directly to the association for payment of any association expense. So you no longer can use debit cards. I'm going to move on. Litigation authority. The association does have authority and ability to, file lawsuits, right? Including, but not limited, against owners who fail to comply. I just want you to be aware of this provision in the statute that says that before commencing litigation against any party in the name of the association involving amounts in controversy in excess of $100,000, the association has to obtain the approval of the owners, and that's a majority of the voting interest at a meeting. All right, architectural control. There was a lot of changes in the statute that took effect July 1st regarding to architectural control. So just wanted to point them out here. But first, again, your authority to review and approve architectural plans for owners who want to make modifications to the exterior of the parcels, well, that authority is derived from your governing documents. So you have to first have the ability to institute architectural standards and then have the ability to approve and disapprove any request, okay? Now, if the declaration or your architectural guidelines, if they provide options for material and size and design to the owners, well, then you cannot restrict the right of owners to select from the options that you're making available, right? So if, for example, you're allowing owners in the community to paint the exterior of the homes in 5 colors, obviously they get to choose any one of those 5 colors, right? What took effect in July 1st is that the association must now reasonably and equitably apply and enforce on all owners the standards that are published. So if you adopt architectural standards, they have to now be applied equitably and uniformly against all owners. And if the board denies, or your architectural review board denies an owner's request for a change to the exterior of the parcel, well, you now you must provide written notice to the owner stating with specificity the specific rule or the covenant on which you're relying upon, and then the specific aspect or part of the improvement that does not conform. All right. So if an owner is looking to change the color of their home and you are disapproving their selected color choice, you have to specifically identify in your disapproval letter, your authority to disapprove the specific change and what part of that request you're disapproving. So maybe the color that they selected is not within the color wheel that's authorized. So you have to identify that specifically. Another change that took effect July 1st. The association can no longer limit or place requirements on the interior of a structure that's not visible from the parcel's frontage or an adjacent parcel or common area or community golf course. So this means that if the owner is looking to remodel their kitchen and you cannot see this from the parcel's frontage, adjacent parcel, or from an adjacent common area or golf course, you can no longer require that owner to get board approval on that specific alteration. You also cannot require the review or approve plan specifications for a central air conditioning, refrigeration, heating, or ventilation system if the system is not visible from the parcel's frontage, adjacent parcel, or an adjacent common area or a community golf course. And that system is substantially similar to a system that is already approved or recommended by the association. Now, section 720.3045 of the Florida statute, well, that was a change that went into effect a couple of years ago. What was new in this legislative session that took effect July 1st are the words in blue. So regardless of any covenant that's in your governing documents or rules, and unless it's prohibited by law or an ordinance, the association cannot restrict owners from installing, displaying, or storing any items on the parcel which are not visible from the parcel's frontage, adjacent parcel, and adjacent common area, a community golf course, and that includes but not limited to artificial turf, boats, flags, vegetable gardens, clotheslines, and recreational vehicles. All right, not going to talk about flags, but I've certainly seen many documents and association rules that prohibit owners from installing or displaying flags. Just note that there is a section in the statute that specifically addresses flags and allows owners to display flags on their property. So you can go back to this later on. Also, be aware, effective July 1st, the association is now required to adopt hurricane protection specification for each structural improvement on the parcel governed by the association. And the statute specifically identifies what hurricane protection includes, but not limited to, and I've identified them here, whether it's roof replacement or whether it's shutters, they're all there. The association cannot deny an application for installation, enhancement, or replacement of hurricane protection by any owner which conforms to these specifications. A very hot, controversial topic is this new legislation that also took effect July 1st concerning trucks and commercial vehicles. So effective July 1st, governing documents cannot prohibit the parking of a personal vehicle, which includes a pickup truck, on the owner's driveway or really anywhere where the individual has a right to park, and it's governed by state, county, and municipal regulations. You also can't prohibit the parking of a work vehicle, regardless of any official insignia or visible designation, which is not a commercial vehicle as defined under section 320.01, subsection 25 of the Florida statute. And I will tell you that the way commercial vehicle is has been defined in that statute is really a vehicle that has a gross weight of 26,001 pounds. So unless the vehicle is of that weight, just because it has, visible equipment or has a sign that says, Joe's Plumbing Truck or Joe's Plumbing, that does not constitute a commercial vehicle, and you can no longer prohibit that vehicle from parking in the community. Now, remember we talked about Kaufman language. So whether or not this particular restriction applies to your community, that is an analysis that you're going to have to do with your legal counsel and get and seek guidance from him or her. Also effective July 1st, you cannot prohibit an owner from inviting, hiring, or allowing a contractor or a worker to work on the owner's parcel solely because that contractor is not on a preferred vendor list of the association. You also cannot prohibit an owner from hiring a contractor who does not have a professional or occupational license. Okay? And you cannot require the contractor or worker to present or prove possession of a professional or occupational license. All right, let's talk about budget and reserves. All right. The association has to prepare every year an annual budget, right, of anticipated revenues and expenses. Your budget will, at a very minimum, have operating expenses, a section where you identify all your operating expenses. You might also have a section that identifies reserves, and we'll talk about that momentarily. But as a practical tip, in the operating section of your budget, right, any money that is in the operating section of your budget, right, they can be used and applied for any bona fide purpose that is identified in your budget without having to get membership approval. So if you've designated a certain amount of money for association insurance and you overestimate it, and let's say you have you're running low on money that you've allocated for a certain type of maintenance, it's okay. You can use monies that you've allocated for budget to pay for certain maintenance of association property or common areas, okay? Now, I've identified here some operating expenses that you might have, including, management fees, maintenance of common areas, certainly taxes, insurance, professional fees, and you might have, others. Now, reserves. This is a tricky one with HOAs because often I see boards that say, well, we have reserves in the budget, right? And we have reserves for, the clubhouse, but can we use these reserves for, to repave our streets? And I always ask the question, well, okay, well, are these reserves that were approved by the owners, or are these reserves that were just established by the board? And there is a distinction. If owners created these reserves, if owners voted for the association to maintain reserves, right? And you can do that by a vote of the majority of the voting interest. And if they did that, if you find in association records that owners created or voted to approve reserves, well, those would be considered then statutory reserves. And under the statute, they have to be funded and maintained in accordance with the statute. If these reserves were not approved by the membership, they were not created by the owners. In other words, it's really more of a contingency fund or a slush fund or however you want to call it that the board has decided to establish for unanticipated expenses. Well, then these reserves are not likely statutory reserves, but really just operating funds. And if these are operating funds, well, then they're not restricted in how they're used and can be used for any bona fide association expense. So for example, if you had a reserve line item designated for, the clubhouse maintenance, and you need to repave your roads if you own them, and you want to use the funds that you've allocated for the clubhouse because, everything's great with the clubhouse this year. Well, if they're not statutory reserves, then they can be used without a vote of the members. So just want you to be aware of that when we're talking about reserves. How you calculate reserves, if there are statutory or if you want to create, a true reserves, well, you really should be having a reserve study done. And a reserve study is done by a professional that comes onto your community, typically an engineer, and will tell you, the remaining useful life of a specific item, and then we'll provide you with a schedule of how much money you would need to collect from owners and put away so that when that useful life runs out and it's time to replace that asset, well, you have the funds there, okay? And then if you have created statutory reserves, well, then the statute tells you that you have to have a certain reserve schedule, and the reserve schedule has to identify certain components, which I've identified here on the slides. Now, important to know that if these are statutory reserves that you have, which were created by owners, well, they're restricted in how they can be used, right? So if you have reserve items, let's continue with our example here with the clubhouse. If you've statutory reserves for the clubhouse and you have statutory reserves for paving and you need to pave, but you're short on funds to pave your streets, well, the only way that you can use reserve funds allocated from, to the clubhouse is if you get a membership vote. So statutory reserve funds can only be used for the particular reserve item that you've allocated. And any alternate use of those reserve funds will require membership approval. Now, if you have statutory reserves and you have separate individual accounts for each reserve item, and you want to pool those reserves, in other words, create a single account with funds for a number of statutory reserve items. So you might include one account with reserves allocated for the clubhouse and paving and maybe painting, some common areas. Well, if you wanted to pool reserves, well, that would require membership vote. But once you pool reserves, one of the benefits is that obviously you can take any monies within the pool for any reserve item that is within the pool. If you want to take any pooled reserves for items that are outside of the pool, obviously that's going to require membership approval. Another point to consider that once you have statutory reserves, you have to fully fund these reserves every year. If you want to give the owners the option to waive reserves at any given year or to only partially fund reserves at any given year, that is a business decision of the board. But again, owners would have to vote on those particular issues. The board can't just make a unilateral decision to not fund reserves on any particular year or to just partially fund them. And if you do have statutory reserves and you want to terminate them, that is an option. But again, that will require vote of the owners. Now, in terms of adopting a budget, the notice requirements for that, well, unless your governing documents provide otherwise, you would only really need to post notice of the meeting at which you're going to adopt your budget at least 48 hours prior to the meeting. But check your bylaws, because typically with regard to budgets, there's I've seen longer notice requirements. So you might have to give owners 10 days or 14 days, but it's all very document specific. So you'll have to you have to look at your documents. Now, after the budget is adopted, before the budget is adopted, there is no at least statutory requirement to give owners a copy of the proposed budget. You might have that requirement in your bylaws, but it's not in the statute. So check your bylaws. After you adopt the budget, there is a statutory requirement to provide owners with a copy of the adopted budget once they've requested one. And if they do request it, you have 10 business days to provide them with the budget. And then again, as of January 1st, a copy of the adopted budget needs to be posted on the website. All right, so we're at 1 o'clock. So I provided some slides here on assessments and foreclosures. I really, in the interest of time, I'm going to skip through them. And I want to, because a lot of this is just, additional information. But what I do want to focus on is covenant enforcement, specifically fining, because the statute does require that particular item to be covered. So let me just kind of skip through these slides. You will have all this information, contracts and bidding. There's a section on estoppel certificates that we have added. Let's see here. All right, covenant enforcement. All right, so with covenant enforcement, and we're going to talk about fining and suspension of use rights here. But essentially, the association is responsible for uniformly enforcing your governing documents, right? So all those use restrictions in your declaration and your rules. And uniformly means against all the owners, right? Not just against, certain owners. Because if you start enforcing covenants selectively, the next time you want to enforce it against, let's say, a new owner, right? That new owner could raise a successful defense of waiver or selective enforcement. Okay, so you want to make sure that you are uniformly enforcing covenants against everybody. And, a number of covenants that you might have, for example, you might have a restriction on pets or on leasing. Might have a restriction against nuisance conduct. So these are all covenants that are enforceable. Now, typically, the first part of the enforcement process is either the association or manager sends out a notice of violation to the owner. If the owner then fails to comply, then the next process is, typically either a second or a final notice. And then at some point, you will want to refer that violation to your legal counsel to send a letter on the attorney's letterhead. And, that typically will encourage compliance. If not, then you're looking at, what are your enforcement options? Well, your options we've identified here in the slide. Essentially, you have the option of fining, suspending use rights. There is the self-help, and then there is the pre-suit mediation, which you have to go through before you file lawsuit, typically as the last resort. So let's talk about fining and use suspensions. So you, the board, you have the ability to fine and suspend the rights of owners to use certain common areas or recreation facilities if the owner or the owner's tenant, guest, invitee has failed to abide by the governing documents or association rules, right? So if you're going to fine or suspend use rights for violations, then that is a two-step process, okay? The first process is that the board has to adopt the fine or the board has to adopt the suspension at a duly noticed meeting, typically 48-hour advance notice. Once the board adopts the fine or the suspension, that fine or suspension cannot be imposed until the violating owner has had an opportunity to go before a committee, and that committee, the notice of that committee meeting has to be provided to the violator at least 14 days prior. Okay, so there is a 14-day notice that you need to provide the violator of that committee hearing before that fine is or suspension is imposed. Now, at that committee hearing, that committee hearing is essentially going to be comprised of at least 3 individuals who are not officers, who are not directors or employees of the association, or the spouse, parent, child, or sibling of the officer, director, or employee. So it has to be a member of the association that is not any of these individuals. And for some communities, that might be difficult. So this might not necessarily even be a viable option of enforcement for you. But for those of you that can obtain these individuals to serve on a committee, then this could be an enforcement option. So that committee hearing, once you've sent out that 14-day notice, that committee hearing has to be held within 90 days of issuing of the notice. And that was actually a new change to the statute that took effect July 1st. The role of the committee at this hearing is really not to negotiate the fine or negotiate the suspension, right? Because the board has already adopted that. The role of this committee really is to ratify or reject the fine or the suspension. So it's a yes or no vote. Now, if the committee does not confirm the fine or the suspension, then obviously that cannot be imposed. Now, within 7 days after that hearing, the committee has to mail or email written notice to the violator of the committee's findings, right? And include whether it's a fine, the applicable amount, or the suspension. You know, you have to identify what facilities, to what facilities you suspended use rights. And then also how the violation can or needs to be cured if the individual has still not cured the violation. Now, if the violation has been cured before the hearing, then the fine cannot be imposed. If the violation is not cured and the fine levied by the board is approved by the committee, then the committee has to identify the date by which that fine has to be paid, and it must be at least 30 days after delivery of the notice of the committee's findings. Now, a fine pursuant to statute cannot exceed $100 per violation unless your documents allow you to fine for more than $100. And then it can be levied on the basis of each day of a continuing violation. So, for example, if you're a no pet community and you have an owner that has a pet and you've already sent the owner violation notice as well, for each day that that pet remains on the property, that's $100, up to a maximum of $1,000 per violation in total for that pet violation, unless of course your documents allow you to impose a higher fine. Now, under the statute, a fine of $1,000 or more may become a lien if your governing documents allow. Okay, so you have to have specific language in your declaration giving you the ability to adopt a fine as a lien. And if you don't have that language, that is an option to amend to give you that authority, right? So sort of given more teeth to that violation and the ability to collect the fine. Now, if you've suspended use rights, well, the suspension will typically apply to your recreation facilities, maybe your pool, your clubhouse, your tennis courts. And if you have the ability to control access to these facilities, whether by deactivating a fob, then yeah, this could be a viable tool. I mean, otherwise you might not find much use in this remedy, but the suspension cannot apply to portions of the common area that's used to provide access. So you cannot prohibit an owner from going into the community if you're a gated community. The owner has to have the ability to access their property. You cannot prohibit utility services. You cannot prohibit an owner or their tenant, guest from having vehicular pedestrian egress to or ingress from the lot. And you certainly cannot prohibit them from parking in the community. And then the suspension applies to a member as well as the member's tenants, guests, invitees, even if the violation resulting in the suspension arose from less than all lot, even if it results from less than all the lot owners violating. Now, a change that went into effect July 1st is that you cannot levy a fine against an owner for leaving their garbage receptacles at the curb or the driveway within 24 hours before or after the designated garbage collection day. And you cannot fine them for leaving their holiday decorations or lights on their home for longer than indicated on the governing document unless the decorations or lights are left up for longer than a week after the association provides them with written notice of the violation. Now, in addition to finding and suspending use rights for violations of the governing documents. The association can also suspend an owner's use rights to common facilities if the owner is delinquent to the association on really any monetary obligation, and the delinquency is for more than 90 days. Now, if you're going to suspend use rights because an owner is delinquent to the association for more than 90 days, that can be done by the board at a board meeting without having this second process of having the committee ratify the decision of the board. So again, if you do suspend an owner's rights to use facilities because of their delinquency, again, it would not apply to, you wouldn't be able to prohibit them from accessing the community, from accessing their lot. You wouldn't be able to suspend utility service or their ability to park. And then once they pay their delinquency and they bring their account current, the suspension will automatically end. You can also suspend an owner's voting rights if the owner is more than 90 days delinquent on a monetary obligation. Now, for many associations, this could be useful, especially if you're looking to get an owner vote, because how this will work is once the board suspends an owner's voting rights due to delinquency, and this is again something that can be done by the board at a board meeting without having this extra committee hearing, but once you suspend an owner's voting rights, then that lot would not be counted towards the voting percentage that you need to obtain. So for example, if you have a community of 100 parcels and you suspend the voting rights of 10 delinquent owners, and let's say you need a vote of a majority of the owners to approve an amendment, well, it would be a majority of the 90, not a majority of the 100 that you would need to obtain. Similarly, for quorum requirements, it would be, if the minimum quorum requirements is 30%, then it would be 30% of the 90 owners, not 30% of the 100 parcels. So could be an effective tool for some associations. Now, if you've tried suspending use rights, if you've tried finding, or even if you don't want to, avail yourself of those remedies, and you want to pursue litigation to force an owner to comply, well, there is a pre-suit mediation process that the association has to go through before the association can file a lawsuit in court. Okay. Now, only certain types of disputes are subject to pre-suit mediation, and we've identified them here. For example, use of or changes to the parcel or the common areas, amendments to association documents, covenant enforcement. Those all require you to go through pre-suit mediation. Now, there are certain disputes that you don't have to go through mediation, and you can file the lawsuit straight in court. Those include, for example, collection. So if you want to file a lien and foreclose on the lien, you can follow that statutory process without doing pre-suit mediation. Eviction or removal of a tenant. If you have the ability to evict in your governing documents and you want to evict a nuisance tenant, you can go straight to filing the lawsuit in court. Obviously, after you've already provided the owner with advance notice of the violation and an opportunity to cure. I'm not gonna spend a lot of time on the pre-suit mediation process. I'm sort of coming to an end of this class, but essentially, your legal counsel will be sending a pre-suit mediation letter to the violator, letting them know that they have to select a certain mediator, and they have to respond to the pre-suit mediation within a certain time frame, within 20 days. And then if they don't respond, or there is an impasse, in other words, you come to mediation and you don't resolve the dispute, then the association's at liberty to filing the lawsuit in court against the owner to force compliance. In terms of attorney's fees and the cost of mediation, both parties will have to split the cost of the mediator, and then each party would be responsible for their own attorney's fees. But then if the association is forced to file the lawsuit against the owner to compel compliance and the association prevails, well, the association would be the prevailing party and it would be entitled to attorney's fees. I'm going to stop there, but know that I have provided some additional slides. There's insurance, and then I believe I added also Fair Housing Act and Assistant Animal slide. So you can read that at your leisure. They're all extra, but there they are. And we do offer another webinar that talks about fair housing and emotional support animals in greater detail. If you're interested, just go on our website and go to the calendar and see when that class is offered. Other than that, I'm going to pause and we'll maybe get to some of your Q&A. Let's see, there's a question here on reserves. Please clear up if reserve studies are required. So there is no statutory requirement for an HOA to have a reserve study. My only point about reserve studies is that if you have statutory reserves, then obviously it would be beneficial to have a reserve study done so that you know what are your reserve items and have a better, what's the word I'm looking, you'll have a reserve schedule basically of the funding that you will need in order to be able to have sufficient funds at the end of the useful life of the asset. But there's no statutory requirement for that. There's a question here, where generally speaking would we typically find the Kaufman language? Kaufman language would typically be found on the first page of your declaration where it references, chapter 720 of the Florida statute, but I mean, it could be on the second or third, where it talks about, the purpose of the community. So, best to get with your legal counsel to confirm whether or not you have Kaufman language. Let's see here. Question here. What is the best way to prevent companies from buying homes for rental? Well, if you want to prohibit entities from purchasing property in the community, you'd have to consider an amendment to your declaration. Okay, so typically the amendment would require membership approval. Now, when we draft these types of amendments, we will typically exempt, obviously, the association because the association can lien and foreclose and take title at the end of foreclosure. And then obviously you'd have to exempt mortgagees, right? Because mortgagees are entitled to also foreclose on mortgages if they're unpaid. And then as a practical matter, you might want to also exempt trusts, revocable trusts that are done for estate planning purposes, because those are becoming increasingly more common. So you'd want to also exempt trusts. Do all HOAs fall under the Corporate Transparency Act? I feel due to lack of access of funds, unless from management company, doesn't apply to the average board. In fact, that is not the position that attorneys in this area of the law have taken. It has been our opinion that the Corporate Transparency Act does apply to community associations. Does the website posting apply to board meetings where members can attend but not actively participate? Yes. So any notice of board meetings also has to be posted on the website, even if owners are just there to listen. Only documents needed to be posted are what homeowners would vote, not necessarily what the board will be voting on. No, that's incorrect. Any document that is associated with the board vote also has to be posted on the website. So if the board is voting on a contract, for example, that contract has to be posted on the website. Can you elaborate on the difference between the 30% of the present members for a vote and the need for a majority of 75% to change the amended docs? So this question is a little bit unclear, but the 30% is a quorum requirement. It is, unless your documents have a lower quorum requirement, 30% is what is the minimum number of owners that either have to be present at a meeting physically in person or by proxy for the board or for the association to even continue with the meeting. So assuming at least 30 people, 30%, let's say of 100 show up, you have quorum, you can move on with your agenda. If your documents specifically say that you require a vote of 75% of all the owners to amend, then that is the vote that you need. Then you need to obtain affirmative votes, either on a ballot or limited proxy, from 75% of the owners, okay? That 30% is simply for you to continue on with the meeting. Let's see here. How do you elect a board with less than 30% at a meeting without written vote? Board with less than, well, I mean, a couple of things. If quorum is 30% and you have less than 30% present at the meeting, then you haven't achieved quorum and you can't even proceed with the meeting or the election. Assuming you have quorum for your annual meeting, then owners get to vote who are present. If your documents allow voting by proxy, then any owner that brought a proxy can also vote for that proxy for the election. So it really just depends on, you know, the election procedure in your governing documents. If our bylaws claim 33% for majority of quorum, does a 30% of the law prevail? The question is a little bit unclear, but essentially, if your documents provide that quorum is 33% of the owners, well, you have to default to what the statute says, 30%. So only if your documents have less than 30% do you go with that. If your documents have more than 30%, you default to 30%. And some of these are hard to answer.
Yeah, and kind of specific.
Yeah.
Let's see.
I mean, just one more. 14-day notice for member meetings for traditional mail. Is it 14 days from mailing or 14 days from receipt of the mail? I mean, typically you have to check the bylaws to see what it says, but typically is 14 days from the date of mailing.
Okay.
All right. That's
Thank
all
you,
the time
ma'am.
we have. I wish I could stay longer.
It's a lot of speaking for nearly 3 hours straight. So thank you for doing that. It's not easy. Thank you very much, Kerstin.
Yeah, thank you so much, Kerstin. As usual, great presentation, very thorough. That's a lot. So thank you. Hope to work with you soon again.